Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering woke panic as Trump wins immunity in Supreme Court. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. The Supreme Court came down with its decision today. Trump got all the immunity he asked for and a little bit extra. I thought he would have wanted total immunity. He didn't actually ask for total immunity. Maybe he wanted to try to keep the presidency accountable in some way. But when the president is elected, they're really the entire executive branch. It's the only position like that. But after this ruling, even though Trump and future presidents will have some accountability, they also have a lot of protection for politicized prosecution. Coming from Breitbart, Trump wins. Supreme Court says presidents covered by immunity for official acts. And from Mother Jones, who is not happy, quote, "The president is now a king." The most blistering lines from dissents in the Trump immunity case. And that actually came from a Supreme Court justice that didn't agree with the immunity decision. What the liberals wanted on the Supreme Court was for the president, as of Trump and going forward, to submit to the Department of Justice so that the Department of Justice could judge anything that they did as president, official acts, unofficial acts. If someone in the Department of Justice, any prosecutor, decided they wanted to pursue a president, they could pursue a president criminally for decisions they made as president. Executive orders, starting wars, whatever it might be that a president actually does. Any decision from a president, that would all be subject to prosecution by Washington, D.C.'s very political Department of Justice. And not just Washington, D.C. Any state, any prosecutor, like they've done in Georgia, like they've done in New York, like they've considered doing in other states, could sue a president and start up a case, and a president, after their term ended, would have to defend themselves against criminal prosecutions. Thanks to the Supreme Court, that's not going to happen. The U.S. Supreme Court ruled in favor of former President Donald Trump on Monday, holding in a 6-3 decision that presidents are covered by limited immunity from criminal prosecutions for actions taken while in office. The court held, according to the summary of the decision, under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. And he's entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. So if presidents make decisions that you don't like in the Department of Justice, you can't just criminally prosecute them and say, oh, here's a statute, one of many, many, many statutes that we read in this unique kind of way that you're now being criminally prosecuted for. Can you imagine if this was allowed to go on? The only reason that Trump can defend himself is that he's very popular. So he has donations to his campaigns that can be used to defend him. And if he didn't have those donations, he'd have a vast personal wealth he could use to defend himself. How could other presidents do this? Do you think Biden has $50 or $100 million to defend himself with when he leaves president? Or Obama had a free $50 or $100 million laying around just to spend on legal fees because someone wanted to go after you? No. The process is the punishment. That's why even with this limited immunity, it's important to make it difficult to chase presidents. Or every president, like Trump has stated correctly, would be under threat of criminal prosecution they would have to deal with when they left office. And if they weren't popular and wealthy like Trump, they wouldn't be able to defend themselves. The court also ruled that a president is entitled to a pretrial hearing on immunity that can be appealed all the way up to the Supreme Court before a trial begins. This means that any trial of former President Trump will take place after the November 5th, 2024 election. Chief Justice Roberts, writing the opinion for the court's conservative majority, said this: "This case poses a question of lasting significance. When may a former president be prosecuted for official acts taken during his presidency? Our nation has never before needed an answer. But in addressing that question today, unlike the political branches and the public at large, we cannot afford to fixate exclusively or even primarily on present exigencies. In a case like this one, focusing on transient results, may have profound consequences for the separation of powers and for the future of our republic. He continues, the president enjoys no immunity for his unofficial acts, and not everything the president does is official. The president is not above the law, but Congress may not criminalize the president's conduct in carrying out the responsibilities of the executive branch under the Constitution. And the system of separated powers designed by the framers has always demanded an energetic, independent executive. The president, therefore, may not be prosecuted for exercising his core constitutional powers, and he is entitled at a minimum to a presumptive immunity from prosecution for all his official acts. That immunity applies equally to all occupants of the Oval Office, regardless of politics, policy, or party. In a footnote, Justice Roberts refers to last week's decision in Fisher v. United States limiting federal prosecutors' use of 18 U.S.C. 1512 to pursue January 6 defendants, saying that the trial court should also determine in the first instance whether the Section 1512c2 charges may proceed. In a concurring opinion, Justice Clarence Thomas questioned the constitutionality of Jack Smith's appointment. He went on to say this, I write separately to highlight another way in which this prosecution may violate our constitutional structure. In this case, the Attorney General purported to appoint a private citizen as special counsel to prosecute a former president on behalf of the United States. But I am not sure that any office for the special counsel has been established by law as the Constitution requires. By requiring that Congress creates federal offices by law, the Constitution imposes an important check against the president. He cannot create offices at his pleasure. If there is no law establishing the office that the special counsel occupies, then he cannot proceed with his prosecution. A private citizen cannot criminally prosecute anyone, let alone a former president. No former president has faced criminal prosecution for his acts while in office in the more than 200 years since the founding of our country. And that is so despite numerous past presidents taking actions that many would argue constitute crimes. If this unprecedented prosecution is to proceed, it must be conducted by someone duly authorized to do so by the American people. The lower courts should thus answer these essential questions concerning the special counsel's appointment before proceeding. We must respect the Constitution's separation of powers in all its forms. Else we risk rendering its protection of liberty a parchment guarantee. A parchment guarantee is something that's just only on paper, where they make you a promise on paper, but it's just on paper. It's not in reality. There's no one standing up for that argument. There's no one protecting your rights. The case will now be remanded and will likely result in the dismissal of some or all of the charges facing the former president in federal court in Washington, D.C. relating to the Capitol riot of January 6th. Now, not everyone agrees that Trump should have any immunity whatsoever. Coming from Mother Jones, quote, the president is now a king, the most blistering lines from the dissents in the Trump immunity case. In response to the Supreme Court's momentous decision ruling that presidents are immune from criminal prosecution for official acts, Justices Sonia Sotomayor and Ketanji Brown Jackson issued blistering dissents. They blasted the reasoning of the 6 conservative justices who essentially created a new power for presidents. No, they didn't. The power was always there. They had to recognize it because of the political prosecutions. Each contended this decision poses a fundamental threat to American democracy and the rule of law. This is how Sotomayor put it. The President of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way, under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy SEAL Team 6 to assassinate a political rival. And by the way, the SEAL Team 6 are honorable people. They're not out killing people. That's not their function. And it's a slur on the military to keep referring to this. They're not just going to go out and commit illegal acts. Just because the president tells you to do something, or just because your chain of command would tell the military to do something, it would not absolve them from personal responsibility in committing war crimes. But when it comes to accumulating power, these people don't care about their victims. They don't care about disregarding SEAL Team 6 or the Navy or having any appreciation for the people that they're smearing. If the president organizes a military dissenting coup to hold on to power, immune. Also not true. That's not within the president's official acts. Takes a bribe in exchange for a pardon? Immune, 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 immune. No, you can't take bribes when you're in government. There are laws against it. And always, as it's always been, a president can be impeached if they do something terrible, even if they do something that politically Congress doesn't like, even if it's not a high crime or misdemeanor. Congress, like Nancy Pelosi did, can just decide, hey, we don't like you, we're going to impeach you. We're going to accuse you of something without evidence for it, and we're going to impeach you. And if they vote to impeach, they impeach. That's the power of Congress. It still has to get past the Senate. But that's how the government works. So that you can't have individual prosecutors decide, oh, politically we're going after this guy, let's put him in jail. Let's threaten him criminally so he can't make decisions that he needs to make for the country. Sorry, Department of Justice, you've just lost a lot of power. The Department of Justice, and this is not the first case, has abused their power. They overextended themselves just to get Trump. And now they're paying the price for it. She continues, let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he one day may face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That's the majority's message today. Of course, that's not the majority's message. The majority's message is, hey, lady, wake up. This guy, whether it's Trump or anyone else who makes it into the presidency, will be the head of the executive branch chosen by the people, kept in check by Congress. That's what's supposed to happen. They do have a lot of power. They're not above the law, but they're not under the law. And while they're a constitutional officer, what they do on behalf of the country, even if people don't like it, is protected from political criminal prosecutions. They also have pardon power, and most constitutional scholars say you can pardon yourself. So now when a president takes office, they would be wise to pardon themselves for anything that could be considered not an official act. So we've created a little bit of nonsense here with this ruling, but it was necessary because of the political prosecutions. Justice Jackson made a similar and distressing point. Thus, even a hypothetical president who admits to having ordered the assassinations of political rivals or critics, or one who indisputably instigates an unsuccessful coup, has a fair shot at getting immunity under the majority's new presidential accountability model. Just because you accuse someone of trying to take over the government, if you don't actually have evidence for it, if you're not actually even willing to charge that person with insurrection or sedition, which the government was not willing to do with Trump, even though they knew they were making up these accusations, if you're not willing to pursue it, sorry, just saying it a lot of times in the media doesn't make it true. They each argued that the conservatives, led by Chief Justice John Roberts, had elevated the presidency to something akin to royalty. Sotomayor wrote, the relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now the king above the law. Here are some of their most hysterical excerpts from their minority opinions. From Justice Sonia Sotomayor. Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle foundational to our Constitution and system of government, that no man is above the law. Same could be said for qualified immunity for police officers, which is why they want to take away qualified immunity for police officers. Relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president, the court gives former President Trump all the immunity he asked for and more. She is correct about that. He didn't ask for that much immunity. They did give him as much immunity as he asked for and more. But it's not just for President Trump. It's for all presidents, backwards and forwards into the future. The court now confronts a question it has never had to answer in the nation's history: whether a former president enjoys immunity from federal criminal prosecution. The majority thinks he should. And so it invents an atextual, ahistorical, and unjustifiable immunity that puts the president above the law. Whether described as presumptive or absolute, under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. So just because liberals, just because people who are trying to push a completely unnatural woke agenda want to say that your actions are corrupt, they should be able to investigate criminally and prosecute criminally whomever they don't like, including a president of the United States acting on behalf of the country. That's what they're arguing for. Just give them all of the power to prosecute presidents after they leave office. And the only thing stopping these people from prosecuting a president while he's in office is a memo in the Department of Justice. So how long will it take until they write a new memo that says, you know what, we can criminally prosecute you while you're in office? Finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent in prosecuting private offenses, is nonsensical. Oh no, it's not nonsensical. Here's what they're saying. The Supreme Court ruled that you can't go and say, listen, I need to know what all of your official acts are. I need to take your official acts and see if I can construe them as an unofficial act somehow, that you used official acts in an unofficial way. So maybe I could do a RICO prosecution or some other corrupt fraud prosecution, like they're trying to do a fraud on the public for voting. The Supreme Court said, no, you can't play around with the President of the United States official acts. You can't get inside and subpoena members of the administration and harass them to try to make criminal cases as much as you want. All of that is now completely off limits. It doesn't mean they won't try to mess around with Trump. They will still do whatever they can to mess around with Trump, especially to affect the coming election. But because they took such aggressive shots at Trump and they missed, the Supreme Court was forced to take this thing up and begin to figure out how to deal with politicized prosecutions against presidents. And as a result, presidents have now clear criminal immunity, just like they had civil immunity for any official acts while president. No doubt this destroys not just the Jack Smith prosecutions, but future prosecutions they were planning to do to intimidate and destroy their future political opposition. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.